accordance with Chapter 231, Public Laws of 1975, adequate notice of this meeting was provided by resolution of the Municipal Council adopted on June 18, 2024, setting forth the schedule of meetings for the year 2024-2025. Said notice was published and posted on the City Hall Bulletin Board by the Office of the City Clerk. Please be further advised, this meeting will be conducted in person. The Zoom stream provided is for viewing only and is offered to the public as a convenience. On December 6, 2024, public notice and Zoom instructions for this meeting were published in the Herald News and posted at the City of Passaic website at www.cityofpassaic.com. Council agendas. Instructions are also available on the last page of this agenda. Please be guided accordingly. Councilman Love,
Present.
Councilman Monk,
Present.
Councilwoman Mello,
Present.
Councilman Schwartz,
Present.
Councilman Garcia,
Present.
Councilman Colon Montañez. Councilwoman, can you please rise for the
Yes,
invocation?
sorry. Heavenly Father, we want to thank you, Lord, for allowing us to meet this evening. Heavenly Father, Lord, we present to you the agenda that has been set before us this very moment, and we ask you to please guide us in the decisions that will take place this evening, Lord, and we ask that you bring with health our council president. In your beloved name we pray. Amen.
Mayor. Mayor's report. The mayor's report.
I'm sorry,
Oh, what? Listen.
Council President Scher is unable to attend today's meeting, and he has designated Councilman Monk to preside over the meeting in his absence. Thank you.
Yeah, the opening. Yeah, and the court. And the court.
It's your update.
It's ready.
It's
It's
mayor's
ready.
update.
It's
Yeah,
ready.
mayor's
Yeah.
update.
I thought we. I'm sorry. This one.
Pinata drop, Pinata drop, which will occur on May 9th as it does each year. Our programming will begin around 8 o'clock at night and will conclude after 12 o'clock. I know that in Third Ward Memorial Park by Hughes Lake, many have seen some work being done. We have some pipe replacements there funded by FEMA. We continue to mitigate concerns of flooding issues, and there have been a number of advancements in the investment in the area, not just there, but in all of our parks. We have a recent update through the county as we move forward with the combining of Pulaski Park and Dundee Island and the expansion into North Pulaski and East Monroe. There are some challenges that we're facing with the land, and the date in terms of completion may have been put off a little bit, but we continue forward, working together in a collaborative manner to provide and enhance open space and recreation opportunities for all of our community. Over the last couple of weeks, we have held a number of activities. At the last meeting, we discussed the tree lighting ceremony as well as the holiday in the park. There were huge successes, and we continue to gather a number of toys from donations that have come from the Marines. I want to thank Mario as well as our business administrator, Rick Fernandez, gave a personal donation of toys. Some other staff members and different agencies have joined with us as we always provide for needy families in the city. I want to remind the community that our parking will be free until January 7th. January 7th, I believe, is the last day right after Three Kings Day, which is the 6th of January. And then beginning that Monday, we will go right into paid parking. We had an extended period of free parking this year in order to ensure that everyone enjoys the holidays, as we are an extremely diverse community celebrating many different holidays. We understand as we approach whether Kwanzaa or Hanukkah or Christmas, which I think this year Hanukkah and Christmas fall on the exact same day. We will continue all of the activities that we do throughout the year. Many have seen the uniform decorations that we've done throughout Main Avenue. As always, I remind individuals that they should put out their garbage in containers, as we have experienced very windy conditions over the last few weeks, which have resulted in an increase of litter throughout the city. But DPW has been working round the clock. Not only together can we maintain our city clean. That's going to be the extent of my reports for now. Thank you, sir.
Thank you, Mayor. Also, there's some addendums to the agenda for this evening. Addendum 43A, and there's a backup to item number 44. Any objections?
Yeah, just by way of background and the reason for the walk-on. So the request is from the owners of 26 Jefferson, the old Passaic site. They're a logistics center that are in the process of selling it to another larger nationally logistics center. And we have been reviewing this since Thanksgiving, roughly. And ultimately, they're planning on closing next Monday, hence the urgency from them. We had done all our due diligence. Unfortunately, the due diligence didn't finish until late last week, specifically Friday, which the packets already went out and everything already happened. And we had asked to see if we can put it on January 7th, but the property owners were adamant that the closing is happening next Monday, and this is the last piece to close if the council sees fit to pass it. As it is, basically all we're doing is transferring it from one urban renewal to another urban renewal. And I've added as background all of the information for the new property purchaser. And as you can see, they're a very renowned and well-known logistics center throughout the country. So we added that so that the council had it in their deliberation.
So the terms all stay the same?
Everything's exactly the same. The only thing that's going to change is the name of the urban renewal as required by law. And as the council may or may not know, the term starts from the previous year's count. So if this is year 5, this owner gets it from year 6 to year 30. So they don't get extra because of this. They start where the other one left off.
Doesn't reset the clock.
It does not reset the clock. In fact, it's a requirement of the long-term tax abatement law. We can't do that even if we wanted to.
Okay, great, thanks. So any objections to adding 43A? I see no objections. Okay, and then there's also a backup to item 44, which is, I guess, additional information.
Yeah,
to the
so
owners.
this was provided by our rent leveling attorney to simplify the original listing, which had almost verbatim the ordinances with a lot of data. This is just to summarize that data from the last memo so that you can see exactly the comparisons to the proposal versus the other municipalities.
Great, thank you. Okay, up to item 5, discussion of the rent leveling board. I'm not sure exactly what,
You
this
have
has
a
to do with the
discussion
ordinance?
item. You
40,
have a discussion item in your packet.
okay. I had, that's the same, I guess it's the ordinance, right? It's to the background.
At the end, 44.
Oh, this stuff here?
44.
Is it this?
44.
44, it is 44. Right.
Well, I think, if I may, council members, the reason I was there is because at the last council meeting, the council decided to leave that on as a discussion for the actual members, not the ordinance. This was the discussion of the members that were there and whether we're going to appoint them and how that was going to occur. So I think that's why that was there. And then there's item 44, which addresses this as well as other items that the mayor and the council have discussed in the past. Is that accurate, Mayor? Yes.
Item 44 also addresses somewhat about the board itself. It
And that is
defines, it does, thank you. It does define in there in terms of what's called a landowner, a homeowner, so on and so forth.
Yes, based on the last meeting, the the mayor had discussed about adding that as part of the ordinance amendment so that the council would have it before them so they can look, see what it looks like. And that is correct. One of the amendments to the ordinance would clarify the definitions of each of the members and also include the homeowner as a permissible member, as discussed at the last meeting and brought up by Councilwoman Colon Montañez.
Okay, so do we have any questions or comments regarding the board itself at this time?
So, so was he, on the memorandum, is this what we're going to be addressing? Because I see there's proposed amendments to the chapter 231.
So if I may, and again,
Yeah,
if
is
I
that-
misrepresent what the council did at last meeting, I think the discussion was whether you're going to appoint the members that you had
Okay,
that day right now, because at least two for sure can be appointed immediately.
yes.
And one, based on this amendment, can also be appointed, and one would argue the level of expertise of that individual as well, which could be discussed. And if the council feels so fit to do so, could appoint
Okay,
the members. And then we have the amendment to the ordinance, which makes that clarity, as well as some other changes within the ordinance. So I believe that's how it was set up from last meeting. So I think the discussion items, and we do have the resolution here from last meeting appointing those individuals, but that would require the council to say, we're going to do that, and then we can add those on.
I don't think, part of the packet, I don't think we have those names here.
not
This
in
pack-
this one, but we were,
No, we
It
have.
was in the,
We
it was
had
in
on the
last week's
previous- Last week's
packet.
packet, right.
It was in last week's packet, but Madam Clerk, in preparation, in case the council needed it, has brought the copies from last week.
In terms of questions to the ordinance, we should say for discussing the ordinance, or should that be part of this conversation as well?
I guess we could save that for later.
For later.
We get to, maybe we'll get to that ordinance, council. Okay. I guess there's no, is there any, is it time sensitive to vote to put these individuals on the board? Or at the next meeting, it's,
So I can only tell you where we are right now with the current situation, which brought this up, and we do have our rent leveling attorney here in case there's any questions. But my understanding is there's been mediation trying to avoid the hearing, and at the last discussion, the attorney for the tenant kind of did not want to hear anything and wanted to go to a hearing, which then makes this a little bit more urgent than it would have been normally, and puts this at the forefront of discussion. Right, so there have been meetings, there have been negotiations, and then ultimately, as part of the mediation, the tenant's attorney felt that it would suit their client, it'd be the best interest of their client to go to the hearing.
so we need a board, I guess. For that.
Yes, and if you do notice, one of the discussions, and the mayor had discussed putting into this amendment, which we did, is an alternative in case the board is incomplete, so that in the interim, there's still action that could be taken on these issues in the interim of that happening. Because I know Susie was working on, maybe a hearing officer or not. This kind of sets up a multifaceted, tiered approach in case there's an incomplete board, that action could still be taken. And then if the council needed, for example, if this ordinance passed, this case wouldn't be so urgent because we'd have an alternative until the board gets voted in.
Council President, and I think that's what we're stalemated at in terms of a board and or hearing officer. So that was the reason why the discussion needed to continue.
Okay, so these members that are being proposed here is to be permanent board members? I say permanent, I mean, for how many, what's the term?
So the
There's
term
no,
is-
we don't have a resolution here.
Sir, the terms are 4 years. Don't you have the resolution there? I thought you handed out the resolutions.
Yes.
Yeah, if you can please hand the resolutions out. So this was, everything that you have just been handed was from last week's packet. So they're 4-year terms. And it's a 3-member board with 3 alternates. So if the council so choose to appoint 6 members, they could appoint 6 members because there's 3 permanent and 3 alternates.
Okay, so is there a desire to add this resolution to tonight's agenda? Do we want to add this resolution to tonight's agenda? Okay, are there any objections?
No.
Okay, so let's, what numbers should we make this then? 43B?
43B.
Okay,
So being no objections, we'll be adding item 43B, resolution appointing members to the rent leveling board of the city of Passaic.
okay. All right, up to Roman numeral 6, minutes.
Can I please have a motion in a second to adopt the minutes for October 1st and October 15th?
So move.
Second.
Councilman Love,
Yes.
Councilwoman Mello,
Yes.
Councilman Schwartz,
Yes.
Councilman Garcia,
Yes.
Councilwoman Colom Montañez, and Council President Monk.
Yes. Okay, we're up to number 6, hearing of number 7, actually.
7, hearing of
Hearing of
citizens. In accordance with the Open Public Meeting Act, NJSA 10:4-1XX, the council opens every public meeting for comment of the public. However, in accordance with NJSA 10:4-12, nothing in this act shall be construed to limit the discretion of the public body to permit, prohibit, or regulate the active participation at any meeting. Therefore, please be advised that the council will not entertain any comments from persons who communicate obscene material, make statements which are considered bias, intimidation, in which a person intends to intimidate any individual or group based on race, color, religion, gender, handicap, sexual orientation, or ethnicity, or makes comments intending to harass or speak offensive language. The person who makes these statements will relinquish their allotted 5 minutes for the public. The clerk has 2 bells. One will ring at 4 minutes and one will ring at your remaining minute for a total of 5 minutes.
Thank you, thank you. Anyone would like to address the council at this time?
Yes, good evening. Council President Monk. My first question is, we have veteran banners along Main Avenue and some other side streets and all. My question to that is, we're in the winter. I remember last winter, I found a lot of them on the ground and I brought them in. I'm just wondering if they could be taken down for the winter and put back up in the spring. That's my question to
Excuse me,
that.
which banner, what type of banners?
The veterans banners that's on the poles,
The banners on the poles.
if they could be taken down for the winter, be put back in the spring. Because during the winter with the wind and all, even though the ties are there, they're ripping the banners. And other towns, that's what they do too, like in Wallington and Rutherford, that's what they do. They take them down. That's my first question. My next question, tonight's agenda, item number 8. Team Passaic, 522 Passaic Avenue. 522 Passaic Avenue, isn't that the Veterans Hall? Why is it being called Team Passaic? That's my question. I think it's disabled veterans. My next one is, on tonight's agenda, Item 23.
Which item?
Item 23.
23?
Yeah. Contractor inspection management on Howard Avenue and Tennis Court. I don't know if you remember, a couple of years ago, there was a lot of issues in that area because you got the houses on both sides of the street, and they have some kind of underground water that goes into the park where they have the parking lot. The one side that always gets flooded. It's like a swamp over there. And all that water goes into the brook and then it goes downstream. So the question that I have here is, in fact, I even brought it to the engineer and they were supposed to have looked into it, but nobody really found any causes there. And plus you have drainage coming off the back going towards the park. All the home drainage, when it's raining, it all goes into the park. So there's a big issue here. These are my questions tonight.
Okay, thank you. Thank you. So I guess the first question regarding the banners, just a question for the mayor of the business ministry. Mhm.
I will readdress it, speak to our BPW, as well as consider some advice from our engineer. And if they believe that it's wise to take them down, we'll explore that option. If not, and they can guarantee that the banners will be addressed by case. For the most part, the majority of the banners remained on the post. We have well over 100 banners. And I think it was less than 10 that came down. We try to reinforce them. And if there's any concern, then we will consider taking them down. I know other municipalities have, and other municipalities keep them up all year. I know for the veterans during the holidays, they really prefer to have their veterans pictures up. And many families have become accustomed to driving around and seeing us honor those who have served our nation.
Right. Okay. And thank you, Mayor.
If I may,
Sure.
and Mayor, I agree. I mean, our veterans over the years have fought through a lot of different weathers and endured all types of conditions for our freedom. So I think those banners should stay up as long as they can all year long, and we should do just what we've been doing, reinforcing those 5 or 10 that comes down.
Thank you, Councilman. Item to question number, the second question I had was regarding the entertainment license. I guess the mayor, Team Passaic has their own license there at this location?
I believe that is referring to a not-for-profit organization, a 501. You see, the DAV is now located at 135 Summer Street, where the VFW, the DAV, and the American Legions merged. The building itself is not the DAV. The organization by state direction had moved, so the building itself is no longer under them. But I can't speak as to the ordinance. I'm just familiar with the process as to the address.
Okay, thank you. And regarding your question, the third question, item number 23, I'm not so sure that this ordinance, this resolution is addressing that home. You're referring to the house that's at the bottom of Pennington. That's between.
No, nothing to do with Pennington.
You said
I'm talking on Howard. All those homes on Howard, there's water
the back to
underneath.
back.
Yeah, this is the issue it's this inspection management
Okay.
that is a hiring.
Mr.
They can look into the whole area.
This addresses the tennis courts, the flooding in the brook.
So yeah, if the council obviously is aware, there used to be major flooding issues. And I know the mayor's reported on many occasions that the work that we've done there so far has significantly reduced the amount of flooding that has there, especially the parking lot with the new drainage pits. This continues along that same approach. And this is for the design of a further drainage system and the construction oversight as part of the project. This is another phase in the drainage system, and then we hope to have an additional phase that would then address the road itself on Benson. So these are all part of hazard mitigation that we've been working through with FEMA and Green Acres and our engineers to try to greatly reduce the amount of flooding. I mean, the mayor has discussed many a times about, adding additional green space. That'll be the next phase, right? Adding additional green space, rerouting the road so that there's a lot more ability for the area to absorb the water and feed it into the brook to go into the river. So this is just one part of many parts for this exact issue, to address the exact flooding issue and also maintain the longevity of the tennis courts. Council may recall, we did a project not too long ago where we resurfaced the tennis courts, and Howard Avenue tennis courts were redone. And one of the issues was where the drainage came off of the hill down the train tracks. So this addresses all of that.
So specifically, which area is this resolution address?
Benson Avenue, the Howard Avenue tennis courts. So it's basically next to the animal shelter. That's where this project would be, that area there by Benson, the train trestle and the courts.
So from under the tracks at the bottom of Pennington, from under the tracks to Main Avenue? Is that correct?
Yeah, so from Main Avenue all the way to Pennington, we've done work from the corner with a new parking lot and some drainage improvements. We're adding additional drainage on the Howard Avenue tennis courts, and we hope to obtain funding for the next phase, which is the rerouting or shifting of the road and adding additional green space to absorb, or something sort of in that nature. We're still waiting for the engineers to finish the hydraulics to figure out exactly the best way to minimize that flooding there.
Right. Thank you.
And since we're there about construction, members may note that the bridge also on Pennington, right there on Pennington and Benson, was redone. That leads into the brook right next to that house at the end of Pennington. The city, along with the county, did the work there to repair that underpass.
Okay, thank you. Thank you.
All right, thanks.
Anyone else like to address?
I need a copy of the agenda.
Council President, we're in the middle of a public hearing.
I'm sorry,
We're
sir?
in the middle of a public hearing.
Yes, ma'am.
Hi, good evening. My name is Vanessa Paza. I am the program coordinator for the Passaic City Coalition. We focus on substance use prevention here in the city of Passaic, substance use prevention among youth. And I came here tonight to just highlight some of the work that we've been able to accomplish with the help and support of Mayor Hector Laura and his staff here at City Hall, and a lot of other community members that we've partnered with. Since 2019, we've worked directly with the mayor to establish Mayor Hector Laura's Youth Council. Over the years, we've collectively, youth council members have completed over 1,000 hours in community service, from writing proposals, planning community events such as the mental health walk, autism awareness event, community cleanups, planting daffodils in the city, assisting with food distributions during the pandemic, partnering with liquor stores to place educational stickers and packages to prevent underage drinking. We've partnered with More Than Bootstraps to provide student financial aid services, and so much more. We sponsored about 20 youth council members over the years attend a youth leadership conference. In terms of work in the community, we partnered and collaborated with several of the government offices here in Passaic and local nonprofit organizations, such as holding quarterly community meetings with UPO. We partnered with the Boys and Girls Club to have use their space for those meetings. We've trained over 50 employees in local bars and restaurants with TIPS alcohol beverage server training. We work closely with the mayor's office to coordinate parent suicide prevention education in schools, training recreation staff and school resource officers with a nurtured heart approach training that engages people that work with youth in positive youth engagement strategies, educated counselors in vaping education. Over the years, we trained over 200 parents in cannabis and vaping education, and we worked closely with the city to also develop a community directory for local organizations. In terms of the work that we've done in the schools, we work closely with the Board of Education to create a school policy change that would deter school administrators from sending kids straight to the suspension when they've been caught smoking or with a smoking device, and instead enroll students in education and prevention services, which wasn't always the first option. At the same time, we connected the Passaic Public Schools with access to a bilingual online 7-session vaping prevention program that is offered through the New Jersey Prevention Network. It's a program called Aspire, just to add another tool to their toolkit of resources when it comes to substance use prevention services. And all of this has been accomplished with the support of City Hall, with the support of Mayor Hector Lauren. This is just a really big thank you to all the support that we've received through the city. And I know I only have 5 minutes, but I wanted to mention that we collect local data regularly and try to find areas of need to address and to prevent drug use among youth. And after analyzing several data points, we have consistently seen a rise in nicotine vape and marijuana use among youth here in the city of Passaic. But I want to mention that it's not a local issue, it's a national issue. So we're seeing this across the board. And I had a very detailed discussion with Mayor Laura and his administrative staff about this topic last year. And just want to applaud the mayor, the health department, and the police for taking swift action after we had that discussion last year. And just to give you an idea of how effective that enforcement was, when looking at FDA underage sale inspections between 2012 and 2019, Passaic City historically had a violation rate of less than 15%. After COVID, around 2022, violation rates rose to 5%. And after the enforcement began in 2023, the violation dropped down to 28%. And that is what I call success from when we do enforcement in the city. And just moving forward, there's still a lot of work that needs to be done. And I've provided a packet for each of our council members and people on the panel here. And these are just some of the pictures of some of the work that we've done, but also there on the right-hand side, there is a list of several strategies that have worked in other communities to protect public health and the safety of residents, particularly youth, that would require action from key stakeholders like yourselves. So I would like to, at any point, if anyone's interested in having more discussion.
I want to thank you very much, member. We have a
Thank you.
absolute rule of 5
Thank you
minutes.
so much.
Any questions?
No, thank
No,
you.
thank you so much. To Mayor and to my colleagues, I apologize for being late. Is there anyone else who would like to address the council? That being the
Seeing
case,
no hands, I'm going to close the public portion.
Second,
roll call, please.
Councilman Monk,
Yes.
Councilman Love,
Yes.
Councilwoman Mello,
Yes,
Councilman Schwartz,
yes.
Councilman Garcia,
Yes.
Councilwoman Colon Montañez, and Council President Sher.
Thank you very much. We are up to items
Number
2.
8,
Communications.
communications.
What is it? I'm sorry. Work to room number 7 on our agenda, communications, items 1 through 9. Are there any questions, please, on 1 through 9? Seeing no buts at this time, is there a motion, please, to accept 1 through 9?
So move.
Motion and second. Roll call, please, 1 through 9.
Councilman Monk,
Yes.
Councilman Love,
Yes.
Councilwoman Mello,
yes,
Councilman Schwartz,
Yes,
Councilman Garcia,
Yes.
Councilwoman Colon Montañez, and Council President Sher.
Yes, thank you. All matters listed here under considered routine in nature. Items 10 through 16. Is that correct?
15, sir.
15.
10 through, excuse me, yes, 10 through 15 is a special separate vote on 16.
Please,
Second.
Councilman Monk,
Yes.
Councilman Love,
Yes.
Councilwoman Mello,
yes,
Councilman Schwartz,
yes.
Councilman Garcia,
Yes.
Councilwoman Colon Montañez, and Council President Sher.
Yes, thank you. Now we're up to resolutions.
Item 16, sir.
16. Separate.
Now we need to do item 16. Should have stayed at the traffic accident.
Okay. Can we please have a
Motion
motion?
to accept 16, please.
Move.
Motion and second. Roll call, please, on 16 only.
Councilman Monk,
Yes.
Councilman Love,
Abstention.
Councilman Mello,
Yes.
Councilman Schwartz,
Yes.
Councilman Garcia.
Yes.
Councilman Colom Montañez, and Council President Scheer.
Yes, now we go into resolutions.
Yes, sir.
We're up to Roman numeral 9 on our agenda, resolutions before the council. Number 17 is a resolution authorizing closed executive session to
No, Council President.
Mr. Fernandez.
No, Council President.
Mr. Mayor, sir?
None at this time.
Members of the council. That being the case, we're up to items 18 through 43. Are there any questions, please, on 18 through 43, please?
We also added, Council President, we added a 43B.
Yes, sir.
We have as a 43A as a 43B.
You have it right.
43B is a resolution to vote on members, adding members to the rent liability board. You have a copy of it there?
I'm sorry, sir?
We added a resolution 43B
So I'm informed.
to appoint members to the rent liability.
Yeah.
You have it?
Yes. Yeah. Your question, sir?
No, I just wasn't sure if you're aware that we added that to the
43B.
43B. To change, to move over with the discussion.
Okay, so we're proceeding with the rent leveling board, that's the case?
To appoint members to the rent leveling board.
Very good.
I don't think the names were proposed yet.
I believe,
The
two.
resumes were attached.
have three.
We also have one back.
There's one back to back. Oh, this is another one. Okay.
This is a significant move. I would obviously ask my colleagues to, as I know you do, to approach it as seriously and in depth. Right, good.
We discussed the rent leveling board. We did not discuss yet the ordinance number 44 on the agenda.
We did not discuss item 44.
Right, that's an ordinance, not a resolution.
Right.
Do we need to specify, I guess, each person, what they're being added, appointed for, what position?
Yes.
We have to just, on item 43B, which is appointments to the rent leveling board, we just need to specify what each person is being added to, either as a homeowner or as the expert or landlord.
Yes, sir.
Right, okay, so the names were proposed by, right?
Yes, sir. We would ask, obviously, of the three positions, two of them have requirements, special requirements from anyone else. The one is a landlord, must be a landlord. An expert witness is questionable. What does that really mean? And a renter is a renter. So the only debate, it would seem to me, Councilman, would be in terms of the expert piece. Right? What does expert really mean? It is not defined in the ordinance, and I'm pretty sure from having brothers and daughter-in-laws and the rest of it, is not defining is probably the best thing to do. Someone considers themselves an expert, have a nice day.
I think in the paperwork,
Councilman Pilon, yes.
Council President, I think in the paperwork that they gave us, they added, the visa for three, actually, they added another one, homeowner. Attorney,
So I
for the rent leveling board.
believe the last resume that was submitted will be also considered an expert, as she does have a real estate background.
We're speaking about Marianne Percy.
Yes.
Councilwoman?
As I was explaining, I didn't know if you saw that. I guess the rent leveling, attorney gave us an explanation and also added homeowner as one of the positions. That he explained what expert is, what a tenant is, what's needed to be on. That's it.
So we're maintaining 3 seats on this board, correct?
Mhm.
And the 3 seats, one would be a landlord, one would be a tenant, and one would be an expert. We're all in
Yeah,
agreement.
and we also have an
But-
alternate.
Alternate.
Yeah,
Right.
and that's an alternate.
Thank you, Mayor.
Okay.
Councilman? Councilman, yes. sure.
If I point out, the homeowner definition does not exist yet because that will be part of the ordinance which hasn't yet been passed. Would it be appropriate to be using that definition which doesn't exist yet? So
Suzie?
43B is kind of attached, is kind of dependent on 44.
No, it would not. Right now, the appointments need to work off of the ordinance as it exists.
That is the ordinance that we're
I-
passing or not passing tonight. That's what you're saying?
Well, there's an ordinance for first reading.
Okay.
So, but that's not into effect. Right now, your ordinance provides for a landlord, a tenant, and an expert. So appointments this evening would need to fall into one of those 3 criteria. Should the ordinance, the proposed ordinance pass, then that would also include homeowner. So appointments tonight need to fit into the landlord, tenant, or expert box.
And of the resumes that we have before us, forgive me for not remembering, but Councilman Martinez, you are nominated.
Not nominating anyone right now
Okay.
because mine doesn't fit into the present. Right? That's how I'm understanding it?
For me, I believe last council meeting, it was explained that the ordinance as it reads now does not exclude the possibility of the council appointing a homeowner. It just does not define what the expert is. It really is up to purview of the council to determine whether the homeowner, I know we had open discussion about it, but the ordinance right now does not read that a homeowner cannot be appointed. And I believe the question was asked whether other municipalities do so. Other municipalities have appointed homeowners. So I think there's only 3 present that fit the specific description on the ordinance. And then there's the additional who would be up to the council, if I'm correct. I'm not sure, Madam Attorney.
Yeah, I'm a little
Thank you, ma'am.
confused.
Councilman, I'm sorry?
I said I'm a little confused. So right now we can, it's the one that, right now we can appoint, even though,
I think
the expert can be, or all 3 can, it doesn't define what a homeowner was before. Now we can,
right now, the ordinance doesn't have a specific
mean. for a
designation for homeowner. The proposed ordinance does. Now, there's no definition for expert, so there could be discussion as to whether or not the particular person proposed is a homeowner and whether you feel that would satisfy the requirements as an expert. I mean, and that would depend on the specifics of that individual. Are they developing property? Do they own multiple properties? But that would be a discussion that you could have. But if it's someone who, owns a home in town, maybe they fit better in the proposed homeowner category. But right now, you can only appoint someone that's either a landlord, a tenant, or an expert. You can't appoint them simply because they're a homeowner. You'd have to have a.
Is that
An expert.
You'd have to designate, I mean, there may be homeowners that are experts.
Yep.
It may be that you feel that people who own property or have been here, have a special knowledge, or maybe they own multiple properties. I don't know the specifics of the person being proposed. But simply being a homeowner, that person, under the ordinance as it sits tonight, cannot be appointed.
Say that again, please, I'm sorry. That last sentence.
Simply being a homeowner, the ordinance in its present state doesn't permit you to be appointed just for that reason.
Doesn't the word just for that reason speak to motivation, not to fact?
I'm not sure I understand your question.
So Councilman Colon Montañez is foolish enough to want to appoint me to the board. And someone goes up to them and says, what makes you an expert? Right?
Well, your expertise, well, there could
And I
be.
think that, most people would answer better than I could, but I mean, you're an expert because you're an expert. I've got 3 resumes before us, as do my colleagues. And I will tell you, I have the pleasure of knowing 2 of the 3. I'm sure 3 of the 3 are well qualified, but I don't think it's within this purview of the council to psychologically analyze what their motivation is.
Well, this doesn't
And
speak.
it would be, excuse me, I'm sorry, and it would be antithetical to what it is that we do currently with other appointees, right? To other committees and groups.
I wasn't speaking to motivation. I was saying that you would need to just designate someone as an expert.
Okay.
That's more qualifications perhaps than motivation.
Okay.
But that's within the council's decision as to who they deem would fulfill the expert slot, whatever qualifications you think are appropriate.
Good. And right now it is not defined in the bill.
That is correct.
So whoever the council agrees upon.
That's absolutely correct.
Good.
That's what falls in there.
Councilman,
I understand.
have we answered the question?
But I think we have 4 resumes, right, in front
Yes.
of us? Okay. So, yes, I understand now.
Okay.
I know what to do.
Well, what is currently, what is the definition of expert? I know that we have an ordinance in front of us that defines what an expert could be. What's on the books of what defines an expert?
We currently don't have a definition for expert. I think in the past, from discussions, often it was a real estate person or someone with knowledge of property, but there is no definition. So you're free to craft, whatever you think qualifies as an expert, and that's through discussion. So right now, you could say, someone's a contractor, and I think that's an expert, fit for this board.
So why specifically does the rent leveling board have have a requirement of an expert as opposed to a planning board, a zoning board, all other boards that we have in the city? Why is specifically an expert a necessity, a requirement for a rent leveling board?
I wouldn't say it's a necessity. That's the way the ordinance has sat for quite some time. But I think if I was going to guess, that it was to try to affect a balance. We want a landlord, we want a tenant, and then maybe we want someone with some specialized knowledge. And at the time, that was the decision that was reached by the council who enacted the ordinance. But you don't have to have an expert.
Right, so if there was, I mean, I guess I'm sure there was a reason behind to requiring an expert, are we just doing away with that by watering down the definition of an expert? Is that what we want to do? Or is it because we find it difficult to find someone that's an expert? Or do we feel that the board is not that important of a board that we need that level of expertise to help make decisions? I just wonder, why would we want to, if there was a need for an expert, and at one time there was a reason why whoever was sitting on the council felt there was a need of an expert. Do we want to maintain that level for this board?
Councilman, I think that's what.
I'm sorry, Councilman.
I'm sorry.
Councilwoman Montañez.
Excuse me.
Yeah, I'm sorry.
I don't think we're looking to water down anything. I think we're looking for the right person that lives here, that's rented, that was a homeowner or whatever, and has the interest of the people of the community. Where the expert came, I think what we were trying to do is put expert slash homeowner, because if we have a rent leveling attorney, I think the rent leveling attorney is going to be who our expert is. I think the people that are going to be on the board are the ones that are going to be hearing everything and listening to what the needs are and making decision on past experiences, right? We all rented. Some of us are landlords, some of us are homeowners, and we're all here to do the right thing for our constituents, right?
Right. So, Councilwoman, so why don't we just call it what it is and just remove the whole word expert? Call it a day. Why are we just trying to, I'll use the word water it down, just get rid of it? If everything fits into expert, as you read the ordinance that's being proposed, just let's get rid of the word expert.
Get rid of, sir?
Get rid of the requirement of an expert. Basically, the way this new ordinance describes what an expert is, I mean, pretty much anyone will fit into that box. So just get rid of the word expert. Let's not make someone called an expert who's not really an expert.
Councilman, if I may, in the ordinance, I believe it was included contractors or individuals who can assess the degree of repairs in relation to any requests for an increase. I think I agree with your position in that if anyone can fit as expert, then what's the purpose of having an expert there? It may even add more weight to that person's perspective than anyone else referring to them. I don't think it's arbitrary. I actually believe that it is defined with the direction of the rent leveling attorney and the city attorney. They define specific descriptions of what could fall into expert. But at the direction of the council president at the previous meeting, we looked into what other municipalities had done, and it came about that Councilwoman Maritza Colón Montañez was correct. Other municipalities added homeowner to it. If I may, and I don't want to take up any time, I'll give you a little bit of a perspective of the conversation I had with the attorney as I was trying to figure out what's an expert, same as you. I tried to understand why a homeowner wouldn't be an expert, because they would be directly affected by decisions that are made. If you own a one-family home and decisions regarding rent or ordinance are made, it affects your neighborhood. But then that begs the question, how much are you affected? If it is only you personally, and I think that that's where the perspective of a sitting council, I would propose, lied, is an individual homeowner will consider the impact on my neighborhood. Whereas an expert, whether it's an attorney, a realtor, a contractor, will consider it from a broader perspective. How does it affect the city as a whole? I think that may be the slippery slope if we begin to designate individuals as experts who do not have that perspective, then it may become extremely subjective. No one would argue three individuals with three different backgrounds. It could be subjective anyway, they can decide. But I believe the point of the expert is to have someone who can objectively consider the case before them and weigh whether or not it impacts the city as a whole, as opposed to, I don't want someone having that decision on Myrtle Avenue or on Summer Street because that's where you live. And I would argue that every member here, whether it's a homeowner or a renter, will consider the entire city as a whole. But I think the expert definition that was given is realtor, contractor, obviously an attorney or anyone that can speak towards a broad perspective in terms of the impact of any decision made by the rent leveling board. But as it sits now, there are three individuals that fit the ordinance and one who would just be a homeowner. As to the council president's question, I think I understood at first, the qualifier would be just a homeowner. Is that sufficient to be included in the group? And other municipalities have said yes, and some municipalities have said no.
Yeah, thank you very much. Council President, for me? Yeah.
Bear with me just a moment, Councilman, if you wouldn't mind. Mayor, so other communities that you've spoken with have a board of three?
With alternates and have included homeowners as individuals who would be impacted by the decisions made.
So if in the ordinance, if one person is a expert, one person is a tenant,
And one a landlord.
and when a landlord, the expert could be anyone, yes? Could it be two landlords? Or two?
If the landlord holds a different charge, so if you're a landlord who's also a realtor, a landlord who's an attorney, you can't be put in as a landlord, but you would have to consider whether their role as an expert would be considered. So it would not exclude someone who's a tenant from being an expert if they're a tenant and fall into the category of a contractor or an attorney or a realtor, then they would be appointed as that, but not as the tenant.
Could it be a tenant whose domicile is the city of Passaic?
I'm sorry?
Who lives in the city of Passaic?
I think that the ordinance requires you to be a resident of the city of Passaic.
That's for all
They have to have
three.
a vested, I think that's where conversation was going in our last meeting, whether you have a vested interest, and if you are a resident who is a homeowner, you have a vested interest in decisions that are made. But whether that qualifies you as a specific expert, I will say for the sake of transparency, the attorney who is present did not feel that a homeowner would be an expert, but did agree that the addition of a homeowner has been acceptable in other municipalities. So in terms of the definition, I believe the clear definition would be someone who is in a field specific to the cases that will be heard from a broad perspective, meaning you're not claiming one individual aspect of whatever role you're in, saying, well, I live on this block and that's where most people rent, so I'm an expert. You know, the decisions that are made affect the city as a whole, so you have to have some kind of backgrounds where a realtor understands the market and has experience of how it is affected and decisions that are being made in terms of what's available, rent or otherwise buying homes throughout the entire city. An individual homeowner, which I would say is a stakeholder, is directly impacted by the decisions made and might bring unique perspective without something additional. Like a councilman who's also a homeowner would be an expert because they consider decisions that impact the city as a whole, but it would be more their council experience than the homeowner. But other municipalities have simply said homeowners can be included.
So if I may, I own a home, and I am a realtor by profession, which I would suggest would be qualification. And I also rent. With one person, you're getting a truck full of nuts, all three.
Yes. You are not disqualified because there's already a tenant, because you would be appointed as the realtor. Unless there's already a realtor, then you would be appointed as a tenant. But there's nothing in the ordinance, and I would obviously defer to the expertise of the attorney. There's nothing in the ordinance that states you can only have one individual occupy a specific category exclusively, meaning you're appointing the individual for their role. So if I am a tenant who also owns property, I choose to own property, I'm a landlord, but I rent at a building where I want to live, and I'm a realtor, you can only appoint me as one. And if there's someone else who's a realtor and you're appointing me as a tenant, that person can be appointed as a realtor and I can stay on because I'm appointed as the tenant. The additional role does not exclude me or somehow disqualify me because there's somebody else who shares that role as long as I'm not being appointed because of that role. Yeah.
So just real quick,
Excuse me, thank you.
because of the tenancy requirement of this ordinance, every expert is either going to be a landlord or a tenant because you have to live in the city of Passaic. So you're either renting in the city of Passaic, who is an expert, you're either a landlord who is an expert. So one would argue that an expert is going to be also a tenant or also a landlord because you're required to live in the city of Passaic in some shape or form, right? So you have to live here. So whoever's the expert would in essence be also a tenant or also a landlord. They're just not appointed as such.
Would the landlord be in conflict? He or she has self-interest here, making decisions regarding property that might be next door to his.
I think that's the intent. I think the intent is to have two perspectives because this would be the majority of cases, landlord tenants. So you have one tenant, one landlord, individuals that represent the groups that would be heard by the board. And then the objective expert, the intention would be that the expert would be the objective sort of splitting vote on it. And then the attorney would be an additional expert that can guide them to ensure that they're not acting outside of the purview of what is permitted by the law.
And because the ordinance has a hardship clause and a capital improvement clause, right? And hence why the conversation happened, the mayor was adamant to add construction, inspectors, things of that nature, is because they're more equipped to evaluate the value of that repair, well, not repair, because repairs aren't allowed, but capital improvement or hardship, right, that can add to that conversation.
As opposed to aesthetics, to make it clear, and
Right.
for those of us who appreciate layman terms, is if you painted the four walls and come back and said, we raised your rent an additional $800 because we painted your walls, you would have an expert there who would say, no, that is not a capital improvement. You removed a wall in the apartment and expanded square footage, and now you have two bathrooms where you had once one bathroom and an additional bedroom. Then reasonably one can expect that there will be a significant increase in the rent. What you don't want are individuals on a board who are making arbitrary decisions because then that will ultimately result in it coming right back to the council. So I think the goal is to have specific stakeholders. That's where you have the landlord and the tenant. And that's where the cases are going to be heard, almost along the lines of a jury of your peers. Right? A landlord wants to see a landlord up there. A tenant wants to know there's a tenant up there. But then the objective expert, who can be either one of those, but is not appointed as one, will come with an objective third view that could make it more, again, for lack of another term, objective, or equitable, because the council can always refer to it was a third vote and the person has no vested interest other than just being the deciding vote.
Councilman Mike was speaking and I interrupted him. I do apologize. Councilman?
I still don't understand this whole expert. I'm sorry for being so naive. I mean, I think, sitting on the city council, we make bigger decisions than this. And I'm no expert in any field. Over here, there's one board is deciding, and they have to have an expert. I'm trying to understand, and if it's based how the ordinance defines it, I mean, and slash expert slash landlord, right? Or homeowner, right?
It's an expert or a homeowner.
That's not present. Forgive me if I'm incorrect.
It's not
Presently,
present.
it doesn't define it as that. We're asking for it to define it as that, right?
That's correct. Yeah, presently, you're talking about the proposed amended ordinance.
Right.
Yeah,
It's the expert is going to be expert slash homeowner.
Yeah, expert or homeowner.
So
The expert could be a tenant.
You have to
So
have-
when we propose an individual for this third position, we're going to propose them as an expert or as a homeowner?
Yes.
Okay. So
You have to have a landlord and you have to have a tenant, and then the third can be an expert
or a homeowner.
or a homeowner.
Or a homeowner.
So presently, there are 4 applications where you have a tenant, a landlord, 1 realtor, 1 homeowner. You can, if you choose as a council, I believe you'd be able to appoint 3 as permanent and 1 as an alternate, if the council chooses to allow a homeowner.
Okay.
Other questions? If I may, just one last question. We have, as I mentioned before, we have a gentleman and a lady who are renting their apartment. They own property. They own property, and they're very knowledgeable. Isn't it conceivable that we're setting up a scenario where the two of the 3 members are going to be at odds with each other, and the third one is going to make the decision?
I think it's that way on purpose, right? That's why there's 7 council members or 9 planning board members, right? To have that balance where eventually the majority would.
I think the goal is perspective, Council
Right.
President. You want the person who can see through the lenses of the individuals that are coming before them. You want someone who could say, as a tenant, I understand why you may be upset. However, it appears that the expert has given testimony and pointed directly to the fact that this is a reasonable increase. There's been improvements in the apartment. The landlord has made a compelling argument, or the landlord might come in and say, look, as a landlord, I don't agree. I think it's an unconscionable increase. As a landlord, I may sympathize with other landlords, but not to this extent, and it far exceeds any reasonable expectation of increases. But I think that is the goal, that each individual who would come here would have a representative, because if you only had tenants, 3 tenants, then a landlord could, and I would argue and propose, have a right to come back to this council and say, I'm not fairly represented on this board that you've approved. And vice versa, if it was all landlords or all experts, realtors, and they would go, neither of you understand what it's like to rent or to own. You simply buy. You have a commercial interest, or your concern is profit. So I think perhaps, and I don't want to go back into history, but I believe that that may have been the wisdom of the existing council, to look at the idea of having those individuals who represent, or perhaps, again, I'll refer back to that sacred model of justice, where you have a jury of your peers, or those who represent the individuals that come before them, people who would understand what it's like to be homeowner or tenant, or rather landlord and tenant.
I'm always concerned about intervention by government in all matters. In today's world, politics leads us to discuss issues which are, in my opinion, purely personal in matter, in terms of gender and status and everything else that there is. I'm concerned that if one has such a committee, will it affect the marketplace?
So that's a great question. I think one that's important for us to consider, but there may be a dynamic that we have not discussed that may put the council at ease. This board gives its suggestion, its determination at the end after considering and hearing the cases. If the parties do not agree, this goes to tenant landlord court and then goes before a judge. If they cannot agree on a decision, because this comes before the rent leveling board, they have, to a certain extent, powers to say, we have heard this and this is the recommendation and decision that we have made. But the landlord or the tenant always has the option to appeal this to the courts, which is the ultimate authority. This is simply a level of government or another layer that is provided by the city council, no different than if somebody did not agree with a decision in planning or zoning or redevelopment and say, I want to appeal this. They can come back to the board, or they can go somewhere higher. Now, I think with that stated, if we're going to be, again, transparent and fair, we want to make sure we have ethical individuals on that board, because some people may not have the means to go and appeal. If the decision is against a landlord, they may have the resources to say, I'll appeal this. If it's against a vulnerable, to make the image more stark, a single mother who can't afford the fact that a landlord said you're going from 900 to 2,400, and for whatever reason, the board says, we uphold this, I don't have the money to pay the rent, I sure don't have the money to go to court. So, of course, we are responsible individuals, and that's where I think the people that live in Passaic have a vested interest and fall into the category of the description for the ordinance becomes so important. But I do understand your concern. It is a board where, as Councilman Monk shared, you can decide anyone can be on it, but it's also a board that will have some impact. I don't believe, because it's case by case, would have a direct impact on the market as a whole. Meaning you could see this board making one decision on one case and then go the other way on another case, since it all depends on what are the circumstances, how extenuating they are, and what is the compelling argument. At the end of the day, our rent leveling attorney, who is held accountable by the council and this government, would have to give report. So
But by dint of definition, it would seem to me that the attorney would have extraordinary power in terms of interpretation.
the attorney of the board,
Right.
to the extent that they would be able to guide whether or not individuals are making decisions in line with the law and ensure to advise or direction that they can't go outside of the law, meaning they can't allow that board to arbitrarily make decisions that set precedent throughout the entire city. That is not the purview of that board. They don't make precedent for the city. That's why I said one decision made one case will not have any bearing, though you can refer to it on the decision made on the next case. Am I correct on this, Madam Attorney?
You are correct.
Okay.
I mean, and the purpose of the rent leveling attorney board is really to advise as to, this is what the ordinance permits you to do. These are your parameters, and to guide them.
I'm in tenants. I'm paying $1,800 a month. I don't know where these numbers come from, but that's another story. Paying $1,800 a month. Living with me is my wife, my mother, children, right? What happens when a landlord decides to buy a property, raises the rent, and the individuals contact legal aid or whoever to be represented? Is it their conflict of interest by definition?
Yeah, if that's today, Council President, I believe by law, those decisions and those agreements are supposed to be made before finalizing the purchase of a property. If I buy a building that has tenants, that is not, and I will ask obviously for the direction of those who work in the field as experts, though we are still arguing what that means. But you cannot simply buy a building and not have in the contract a clear direction as to what will happen with the tenants, whether you purchase the building with the tenants, continue the lease, whether you need to advise them. The role of the board is to ensure that any action being taken by a landlord or any lack of response by a tenant falls in line with our ordinances and existing laws. So if a landlord is acting outside of that, then that board could say, no, you are not in line, and the attorney could advise and say you are correct in that landlord is acting outside what the ordinance would permit in the city. But I think the exact same laws that govern the exchange of property between a purchaser and a seller remain. Now, we know in a city like ours, and I've received accounts and you've received accounts where individuals go, I wasn't given a lease. The landlord refuses to give me a lease and keeps raising the rent every month and won't even give me receipts for my rent in order to circumvent the process of being held accountable by government. There's no records. I think having a board set and having an attorney and professionals will go a long way in ensuring that the residents of the city know that they have some recourse if this is occurring. Outside of that, we have received direct accounts of individuals going, the landlord rented the room in my apartment and told me if I say anything, I'll be kicked out, and I'm not receiving any receipts for my rent, and he won't give me a lease. Right now, there's nowhere to go outside of giving a complaint to the police in a long bureaucratic process that by the time you get to see anyone who may have the authority to have a decision made in your favor, years have passed.
As a renter, I come to the committee and I make my case. Do I qualify for legal aid, an attorney?
No, I don't believe that would qualify for.
So how does this family, my family, how is it?
I'm sorry, in front of the court, forgive me, Madam Attorney, if that family was to go to the court and they don't have the means, they would qualify for legal aid because that's based on income eligibility. If they're appealing a case and they go before the court, I don't believe that legal aid would be utilized before this particular committee because it's intended to be a step before getting there. Yes. So I don't believe, but I think,
Well,
Madam Attorney,
I thought you were asking me about when they come before the board. They would come on their own.
yeah, before a court, they would qualify if they're income eligible to apply
If
for
they're
legal
income
aid.
eligible, for certain types of things, they'd have to apply.
Aren't these individuals me? I'm at an obvious disadvantage. The landlord who's trying to raise my rent by $1,000 a month, which is ridiculous and unaffordable and all the rest of it. How does one ensure the right of this process that the tenant will have the ability to utilize some experts to help him or her proceed? It would seem right now the landlord inherently has that.
Our rent leveling attorney.
I'm sorry, Mayor?
I think that would be our rent leveling attorney. The rent leveling attorney represents the interests of the city, neither of the landlord or of the tenant, rather one of a legal perspective of what is fair. And whoever is before him, whether it be the tenant or the landlord, can appeal to that. I think that's the presence and why it's so necessary to have the rent leveling attorney present. They are integral in the process. In fact, paramount to ensure that the individual, as you said, can appeal to the attorney and say, is this legal? And that's what the attorney's role would be. Without an attorney, I agree with you, it would not be an effective board, as it would leave it in the hands of individuals that could subjectively and perhaps even unfairly make decisions. But the
Do we
attorney.
have any experience from other municipalities who have rent leveling boards? Have they witnessed increases?
Yes.
Significant increases?
They face increases. Some are significant and are supported. Again, depending on the degree of repairs or the justification. You didn't receive an increase 5 years. You are far below the market. There was a purchase and there were significant changes made to the building. You brought in more people than you initially agreed would rent. And then you have made a request of the landlord, and I'm just throwing out decisions. Initially, it was you and your spouse, or your spouse and a child, and now it's you, your mother, your father, and 2 cousins who live in there, and the landlord is saying the rent will be increased. Each municipality, again, each is a case by case, and it is the responsibility of the individual before the board to make the compelling argument as to why the increase should be upheld or not. And again, the opportunity for appeal is made available to any individual, where they can go to landlord-tenant court. Right now, they're going straight to landlord-tenant court if there's any issue, or just not going at all. And that has been a
One
problem.
question there that I'm kicking myself.
Yeah.
How many cases a year did we have?
That would be challenging for us.
Joyce, I believe, was the.
Good. Yes.
So discussions with the rent leveling attorney, there's been over 55, just in the past 2 years, discussions and over 65 letters that have gone out to tenants and landlords that have been managed by the attorney because in the absence of a board, right? And then unfortunately, at this point, there was one that we could not mediate and required the necessity of a hearing, which is what we're in the process of doing now. So there are significant requests coming to the city on a daily basis, and it's been exacerbated after the pandemic. So just to piggyback on the mayor's comments, this is a statewide issue. It's not a city of Passaic issue. All these towns, even towns that have never had rent control ordinances, right, are talking about doing that because we're not talking about normal increases anymore that are maybe 5, 6, 7, 8%. We're talking about raises. In some cases, Mayor, you brought the other day one that wanted to double the rent
from 900 to 1,800 without a justification,
Oh,
which, if I may, what I was referring to is we can't quantify how many cases. We don't have numbers for how many simply turned away and said, you know what, I'll just leave the apartment. We get a number of those anecdotally. We don't have data on that. We have minimal data on those that we've tried to intervene, where they've actually gone to the courts. And the desire here is obviously for us to provide that opportunity for individuals to be heard in a more effective and organized setting. However, it's also with the absence of a board, what you have are individuals who believe that some extreme approaches may be the best solution because they're not privy to what could be potentially available. So you have individuals saying, if we create this initiative throughout the entire city, it will resolve the problem. And we go, no, it won't. And it hasn't been successful in any other city where extreme measures implemented broadly throughout the city place. And I would argue we've never taken that approach. But without something, and our books, our ordinances say that there is the opportunity to create something, you have some organizations, perhaps very well-meaning, don't make any judgment on motives, who attempt to present direction before the residents of taking broad measures throughout the entire municipality that I don't think anyone in government, regardless of your political views or position, would responsibly support. That's what the other concern is that there's a vacuum. And when there's a vacuum, everyone wants to fill it with their ideas and their suggestions. I think a rent leveling board, and there's going to be some trial and error. That's why we have an attorney, and an attorney can be called in at any time by the council to ask for a report and question and to follow data, and then perhaps visit again and say we must change this ordinance and redo appointments in 4 years. But I think that there is a compelling argument as to why we should have a board, because right now we're just getting people coming to City Hall. I'm calling council members going, and I had one today, literally today, go, and they raised my rent $800, and he wants to rent someone in the apartment that I'm in, take one of the rooms and say, this person is going to live there and won't give me a lease or a receipt. All of these are illegal actions. You're not allowed to do that or impose upon a tenant. We have recourse, just none that can be expedited, whereas this layer of government oversight may be able to expedite a decision and send a message to landlords directly.
Does it also, I promised to wrap up, I apologize to my colleagues.
There's a 6-year sunset, but that's any increase regarding the rent. You see the rent leveling.
Right, so those increases,
Yeah, but that's for the increase, not for the rent leveling in terms of the appointment.
right for the board, but
Yeah.
as the council president was talking about the increases throughout. And
The exorbitant increase.
balance,
I don't know if we got into that topic, but yeah. Since it's brought up, there is a proposal before the council to consider, but that is a separate topic, though related, just a little bit different in terms of capping the amount in which anyone can increase within a single year. And if there is justification or compelling argument to come before the board, that the board, again, with the experts can determine it. So if Councilman Love is renting, Council President, and he invests in significant renovations, perhaps even at the request of the tenant, I want another bathroom. I would like a bigger kitchen. My kitchen is too small, and I would love an island. And Councilman Love and his magnanimous act of, caring for those, says I'm going to invest, and then later decides I need to be reimbursed somehow and make the money. It's not so magnanimous. It's more practical. I need money. Says I want to increase the rent. When the tenant says, no, I'm not paying, it's an unfair rent increase that could come before the board where the expert could speak to it, the degree of the repairs or investment in the apartment, and whether it was justified or whether they come to an agreement in between. Maybe you don't raise 900, 600 makes sense, and you're still there at market.
Last question. I promise.
Yes.
If I were a landlord, if I was in building and construction, and I was going to build 20 apartments, and there'd be 3 apartments would be economically oriented towards the need, right? Why would I want to go to a community that has this kind of instrumentation, which is going to disadvantage me terribly, conceivably? Why wouldn't I go to another municipality with close to or equal desirability, proximity to New York, in terms of all of this stuff?
It's a fair question, and I would respond in this way. There are municipalities that limit the increase at 5% and even less. We did not take that approach. I think we've taken an extremely reasonable approach to ensure that we consider both the landlord and the tenant. This is addressing increases, specific increase from one year to another. In terms of you renting a market, if you begin your apartment and you've made luxury apartments, and I think that there is an argument to be made, I'll throw out some arbitrary numbers to make it fair. If I spend $20 million to buy a property, it was, let's say, off the tax rolls, a not-for-profit organization. I buy the building at $20 million and I invest an additional $40 million. And I make luxury apartments in proximity to New York with a wonderful view. And I set the price for the apartments. This ordinance does not prevent you from setting the price according to the value of the apartment in the market. Now, if you set that apartment, I'll throw out a number at $4,000. People will complain and say, well, I want the luxury apartment that you invested the $20 million in for $800. I've responded to people, if you purchase a home at $500,000, you have a mortgage and the city comes in and after you've calculated, I'm going to rent the first floor for $2,500 and now I only have to pay $1,500. The city says, no, you can only rent at $500. The landlords or the homeowners will go berserk on us and say, I'm going to lose my home because you're dictating how much I'm allowed. I have to pay my mortgage. In the same way, those who buy property, they have obligations. They've taken, whether loans from the bank, they have obligations. So to that extent, you can set your rent. And what you cannot do is rent it at $4,000, and let's say someone in the city decides, I want it for $4,000, and then the next year you've made no repairs, you've done nothing, you say, I'm gonna raise the rent $8,000. You go, how are you justifying this? If you can justify it, you come before the board. If it is not justifiable, you go, listen, you can raise it 20%. That's what people raise all over, but you want to raise 100% of the rent, you have to justify in the city of Passaic. And I believe that we stand on strong ground because we have worked to incentivize developers. We have offered them, whether tax abatements, parking incentives, redevelopment opportunities, locations. We have facilitated the process. Developers work well with us, but we have an obligation to ensure that nobody in the city is unfairly or has to deal with an unconscionable increase of rent, and there's no recourse for them.
Thank you, sir. Thank you for bearing with all my questions. Councilman Mon?
Yeah, thank you, Council President. I just want to address one thing the mayor mentioned just now, and my other questions I'll wait until we get to item 44. But this last point of that, if someone builds a brand new asset in town,
Yes.
and he could set the pricing whatever he wants to, right? Let's say he sets it at $4,000, and this way he could get paid what he believes he needs to make the development work.
Yes.
There's in the real world, it doesn't work like that necessarily. And I'll give you a case in point. Let's take Passaic, Pennington.
Yes.
What's called Pennington Properties, right?
211.
Pennington Properties. This guy dumped in a lot of money into renovating the St. Mary's Hospital, right? It's very typical when you develop something new, or you take an asset and you dump in a lot of money that has a lot of units. The first year that you're leasing out is not necessarily your market rents. If I'm sitting with 100 units and I'm 95% occupied, my next lease, I could wait to get my $4,000. But when I build something new, or I renovate something, old building, now I'm sitting with 100 empty units. I don't charge $4,000 the first year because it's more important for me to fill the place up quickly and wait for year 2 or wait for year 3, because I'd rather be full at $3,000, fill up quickly, and then on my second turn, when I lease on my second turn, then I go to my market rent, what I need to make this investment viable. Then I go to my $4,000. Basically, I'm reading this ordinance, we are going to bankrupt any new development in the city.
Council President, if I may, Councilman, I want to say point well taken, duly noted. Again, I'll go back that the ordinance does not restrict you from doing so, but simply states that if you wish to do so, you have to come before the board. It doesn't say, if you come with that, the first year was 3,000. And it's understandable, and that's why you have the expert on there, and you also have the landlord, the property owner, who would say, yes, just like you just gave an expert testimony, giving context and perspective to why that increase would be justified. That would be how the board would operate. And then ideally, of course, there's no perfect scenario where everything is decided exactly how we think it should. But just as right now in this council, you have an expert perspective, though you argued earlier that you're no expert in anything, but here you are. You have an informed opinion and you gave it. That would operate similarly with the board, where someone would say, yes, your increase makes sense because you rented at far below in order to fill the apartments, and the next year it's justifiable. What this board would be able to oversee, and the intent I would propose of this governing body, is that someone who has no justification cannot get away with saying, I'm going from $900 to $1,800. I've made no repairs. And the tenant has no recourse, and they received a letter, you will be evicted next month if you don't agree to this. Right now, there's no measure to stop that. And that's what it would address. But again, I'll reiterate, it does not restrict a property owner or one who buys an asset from that limit. The individuals themselves may have perspectives. That's why we want to make sure that it is fairly represented with a landlord, a tenant, and an expert witness.
I appreciate that. However,
Excuse me for just a moment, Councilman, if you'll take the presidency for just a few minutes.
Yes. If someone goes before a board that has a landlord, has a tenant, has a homeowner, whatever it is, right?
And an attorney.
And an attorney, right? And I say, you know, I was charging $3,000 when I leased up, but now I need $4,000, right? How do I prove that the market should be $4,000? I'm not doing any renovations. I built a brand new asset.
I think
Obviously, I'm not paying money.
expert witnesses, like any other board, if you go before the planning board or the zoning board, you may bring architects. You may bring a contractor, whoever you're going to bring, you may bring an attorney. You may come before this board and present a compelling argument as to why you must raise or you can't pay, and it doesn't make sense. And when you were first approved for the development, you may show that on the record there was an expectation that this would occur.
So I don't know of any investor that would write a 10 or 12, 20 or $50 million investment in an asset in a city where you don't know what's going to happen in year two.
Mhm.
All right. I don't know a bank necessarily they'll give a loan on an asset so fast if under this scenario. But definitely as an investor will not put money into a new
So they'll know what's going to happen.
because everyone knows that year one you have to give, it's called concessions, right? There are times you give 1 month concessions, 2 month concessions. If let's say,
The councilman just made the argument.
Yeah.
See, forgive me for pointing this out, but you said everyone knows. That
Correct.
would include the members of this board. So if you
I-
say
I don't-
everyone knows a reasonable response.
Mayor, everyone, yeah, but it doesn't guarantee me
No, it doesn't guarantee.
that I'm
You're right.
right. So it's nice to, you know.
But planning board doesn't guarantee zoning board
And
redevelopment.
that's why many times
Yes.
with a planning board, or zoning board, a property, someone will go into contract contingent on getting zoning approval,
Yes.
right? But now, how does someone come and invest in a new asset
Yeah.
and knowing that if they build in Passaic, right?
Mhm.
And then the next thing you know is that in Rutherford, someone puts up 300 units. Now it's a little more difficult now to rent out your new asset you have in Passaic. So you give a 2 month concession,
Yes.
right? So
And you
get
fill it up.
15 just to fill it up.
Yes.
You don't know what this board is going to do.
But you
in
do
year
know
two.
that you can appeal it. I know it becomes a little bit of a challenge if you think, but if in this hypothetical, you're going, the board's not going to make a responsible decision. And I would argue that I believe that individuals within the city and the individuals that are proposed here are reasonable individuals who understand the market, who live in the city. If we appoint individuals who make decisions that will adversely impact our city in terms of investment or development, then we have recourse in saying we won't reappoint them. But if that same argument could be made for every appointment, what if we place someone on the parking authority who makes bad decisions? What if we place individuals on the zoning board who make bad decisions. I think the intent of the appointment and the direction of the council does carry weight. I believe that if a landlord, and again, it can be sensitive, if a landlord decides or a property owner decides, I'm gonna rent at 3,000, which is reasonable, let me fill up the apartments. I need to fill them up. And then I'm gonna increase the rent. I do not see where we would be flooded with cases coming to this board stating, we don't want this increase, because I think people who go into apartments like that have a reasonable expectation. I think there are conversations that happen in the lease. I don't think a property owner who buys an asset, especially we're talking about 40, $50 million in these scenarios, who will not let tenants know in their lease that your increase can go from 3,000 to 4,000 next year. Because if you put a raise outside of the lease anyway, it can be challenged, but you receive a lease to go in these apartments. And those leases become binding contracts legally. And I don't believe there's a responsible developer investment group that would enter people into a contract understanding they're going to increase without addressing it. So I'm not saying it's a moot point. I believe that there is a process to address that.
So Mayor, so you're saying that based on this ordinance, someone could lease an apartment at $3,000 and put in the lease that next year, please be noted. it'll go for
Yes,
4,000?
if you agree to that, you have agreed to it. It is a binding. We have made that clear and we vetted it.
I'm not finished. Okay,
Yes.
1 second. Now, if that apartment the person vacates,
Yes.
okay, now someone else is leasing, right? You could go from 3 to 4,000?
Yes, because you're not increasing on the individual outside of a lease.
Okay, so that's what I'm just.
On vacancy, it's whatever the market.
Okay, so that's what I'm just drawing. I have all these questions. I want to.
Yes.
Driving
And
at.
could I just clarify one thing, that this, to the extent that there's new construction, this isn't applicable.
Yes.
Why is that?
It's state statute that new construction are not subject to rent leveling. So you just have to put a provision in the lease that reflects the statutory criteria.
That's what I was stating with
I
the
didn't
lease.
see it. I thought I read through. I didn't see where.
Well, that wouldn't be in the ordinance. That's state statute that says if a municipality enacts a rent leveling ordinance, new construction is exempt for, I think, the life of the mortgage or 30 years.
That's why I refer back to the lease. That's guided by their lease.
Okay,
Not-
fine, good. I'm just looking for clarity on this.
No, I think this is a healthy discussion.
Yes, I'm looking for.
I appreciate the
okay.
discussion.
So new construction is not,
It does,
all this stuff is not.
As of what
applicable
date?
to new construction.
As of the date of the ordinance or as of the date of the construction?
It's pre-existing.
Statute, so it's just not applicable whether.
So you can't implement any type of rent controls on construction within the first 30 years?
For the life of the mortgage.
And that's what I was trying to say earlier. From what I've read, I don't think this ordinance is yielding to existing properties, because we know there are landlords that have dilapidated property and want to increase, because we've seen that, especially after COVID, and want to increase justifying nothing that they've done.
Okay.
So I think this, from my understanding, from what I read, this is more.
If I may, Council President, just for the sake of Council President, the question was posed that if an asset is purchased, Councilman Monk had shared, and let's say $50 million, and for the intent of filling the apartments, which often occurs, that's the direction that's taken, you rent for $3,000. And then, of course, common practice is the next year you may want to raise it to 4,000, or what would be reasonable for the luxury apartment. To which you clarified that would be governed by the lease, the binding contract that you determine. However, additional information has been shared that by state statute, new constructions would not fall under this ordinance. Rent leveling ordinances or laws would not apply to a new construction or a new asset for the life of the mortgage. So not that it's a moot point, but for all intents and purposes, that is not an issue of concern regarding this particular ordinance. This ordinance would deal with existing property and specific to any exorbitant or outrageous increase, or maybe any increase that falls beyond or goes beyond what limit is proposed, they would have to go to this board and make a compelling argument. So in the scenario of someone saying you paid $900, there's been no repairs, now it's $1,800, and if you don't pay it, you have to leave, that tenant would have the right to request to be seen at the rent leveling board and have the landlord justified, and the rent leveling board would make the determination. And then if the landlord doesn't like it, they can appeal the case, but it does not apply. So the response to the councilman was, we do not believe that it would reasonably deter investors from wanting to come into the city and have a new project.
Good. I'm just trying to flush out.
No, it was a great question.
Mayor, excuse me, the last sentence that you said?
A new project. It would not deter an investor from wanting to come here and have a new project because this law would not apply to them.
And how about an existing structure which is radically?
An existing structure, and if there's a vacancy, we also clarified that. If there's a vacancy, you can rent it, but if you are in the property and you have signed a lease, and let's say your lease allows for $150 increase a year, you signed that. It's a binding contract. You agree to that. But for whatever reason, the landlord arbitrarily or thinks he can justify it by any actions that he's taken throughout the year, says, I want to raise $900 outside of your lease, or you don't have a lease, you can take this to rent leveling to be considered, and the rent leveling board can make the determination that there's no justification for an exorbitant increase and say no. And then the landlord could appeal, or he would accept that decision.
Thank you, sir. Forgive me, I was out for a moment. Councilman?
Yeah, so just to clarify another thing.
Yes.
So that's in this ordinance, I'm looking at C. It's 1, 2, 3, 4, B, under 231-23. Under C, it says the provision of this chapter shall apply to all dwelling units occupied on or after the effective date of this section up until the 6th anniversary of the effective date of this section. Any dwelling unit which becomes vacant throughout the duration of this section's effective period shall not be subject to the provision of this section. So that's just for clarity. So any unit that becomes vacant, you could take it from 800 to 1800. This is to protect the people that are currently living in a unit.
Exactly.
That's what we're trying to protect.
And this entire ordinance after 6 years would have to be revisited by the council to continue, or it ends.
Okay, fine, understood. Okay. So the only, I guess, just trying to think of a scenario of a property that could be technically affected. Is that, let's take Pennington, right? So I believe they underwrote to rent it like at $2,500, right? What I've heard, again, I haven't seen the financials, but just what I've heard, that they wanted to fill up very quickly, which they did. I mean, it's amazing. The parking lot is full already. Yes. The building is full. I think they rented it out like for $1,800, $1,900, right? So under that scenario, why would they be?
It's new construction.
That's considered new construction.
Right, and then the term of the mortgage, the initial term of the mortgage, they're exempted from.
But it doesn't have the original mortgage. They already flipped the property. Someone else already owns this. It's a new mortgage now. It's not the original mortgage from the developer.
So
even more so.
Right, so their loan
Yes.
is based on that $2,500 increase.
What do you mean?
The 25, whatever, the mortgage, right? So when you get the mortgage, you got to show that there's enough income. And if it's already 100% occupied, I'm sorry. If they're already 100% occupied, you know well that the mortgage is going to want to see the current rent rolls,
Right.
and they're basing their mortgage on the current rent rolls. So the argument that they would need more than that to meet their mortgage is a little tough, right? So, but again, if the lease says they can have the increase, the lease can have the increase. If it's under the initial term, if it's under the initial term of the mortgage, it's exempted. And if any of those are vacant, they come in at whatever the market will bear. So those are kind of the general notes.
Yeah, I'm giving a scenario of this ordinance where, again, I don't even know who owns the building, okay?
Yes.
All right, that where, again, just because they can pay the mortgage does not mean that it's valid. They had to put in equity also. Now, they bought this thing to fill it up quickly with the idea, I would imagine, again, I don't have any, but it's what I've heard from the
In the
grapevine.
example, in your hypothetical, if it's a new contract and they have no lease and they were
No
rented
problem.
25,
That's no problem.
then yes, I could see an
Have a
issue.
hardship.
But again, I don't see that being the scenario with professionals going towards that route with no lease and buying the property and now renting at 2,500 with no recourse. I don't see that happening.
But let's say in the rare case that it does, the ordinance, which is not touched with this ordinance, has a hardship component in which they go to the board and show that they're way below the market and the mortgage and their equity, and they're allowed to bring it up. So even in that rare case, which may
This
exist,
allows them to do
it
that.
allows a hardship application to bring it up to what's called fair market, and that analysis is brought before the board analyzes it and can come up with.
I was adamant about that component because of the developer.
Right.
Again, if you are below market and you have the justification, you can automatically bring it up. That's why I do not like the idea of having an approach which is often referred to as rent control or capping at such a low amount that individuals go, I will never recover my investment. This specifically addresses existing property where an individual outside of a lease is facing, what I mean outside of lease, even if they sign one, the increase is not justified by the lease, where someone is giving you an unconscionable rate increase and you have nowhere to go. But this does not refer to new construction, new projects. And again, any project of this magnitude, if you have a luxury apartment, there is a market rate for that apartment. And if you have a lease, that contract is binding. This will not circumvent or supersede any contract that is already existing, meaning this board can't go, we saw your lease, we don't agree with it, and we're going to make a decision that you don't have to pay the lease. You signed your lease when you went in. That is a separate contract.
Okay. This is a question, if I may.
Councilman,
yes.
if you wouldn't mind. For the past while, we've been discussing item 44.
Yeah, yes.
What I would like to do, if you don't mind, if members would allow me, I would like to finish the agenda and at 44 determine what hour it is and people's disposition if we'd like to go forward or to postpone to another meeting in the future. If that's to the council's liking?
Yes.
Very good. With your permission, colleagues, Mr. Mayor, we are before us. Item 18 through 43. I'm sorry, 44. So we will be leaving out for the time being the ordinance 44 as well as 43B. Colleagues, are there any questions on these items? If I can ask everyone to please turn off their lights. Are there any questions, please?
Council President, so will this include 18 to 43A?
I'm sorry, ma'am?
It's going to be 18 to 43A?
You got to give me a little bit louder.
18
To 43A?
18 through 43A inclusive.
Okay.
Are there any questions, please? If not, I'll take a motion, please, to accept items 18 through 43A.
So moved, Council President.
Second.
There's a motion, there's a second. Roll call, please.
Councilman Monk?
Yes.
Councilman Love?
Yes.
Councilwoman Mello?
Yes.
Councilman Schwartz?
Yes.
Councilman Garcia?
Yes.
Councilwoman Colon Montañez?
Yes.
And Council President Scher.
Yes, with the council's kind permission, item number 9, item number 11, excuse me, payment of bills. Are there any questions on the bills? Seeing no lights at this time, is there a motion, please, to accept the bills as presented by the clerk?
So moved.
Motion
Second.
and second. Roll call, please.
Councilman Monk?
Yes.
Councilman Love?
Yes.
Councilwoman Mello?
Yes.
Councilman Schwartz?
Yes.
Councilman Garcia?
Yes.
Councilwoman Colon Montañez?
Yes.
And Council President Scher.
Yes, thank you. I'm going to take the liberty, Mr. Mayor, Mr. Business Administrator, to leave these, to do 43B separately, yes? 43B and, well, we're up to resolutions. Is there a motion to accept? Are there any questions, please? That being the case, is there a motion, please, to accept items
43B.
43B.
We did everything through
43B.
43A.
Did
So
everything
now
else
just up to
up to
43B.
43B, sir.
To pick the names, the rent leveling board, the names, the appointment.
Are you saying,
Would you want to proceed? We have to give recommendations for the different positions.
I'd like to first assure that we have an ordinance with which,
To
application,
address the rent
which
level.
brings us to 44.
Yes.
Sorry.
Originally.
44, we're discussing now.
Yes, okay.
Yes.
We agree?
Yes.
Let's come back to the question, but I would appreciate if we could go thoroughly, but a bit quickly. Mayor, bear with me just a moment.
Oh, I wasn't sure if
Is
that's
there
what
a
you wanted.
motion on 43, excuse me, on 44? Is there a motion to open public hearing?
Move it.
Motion?
Second.
Second, roll call to open public hearing.
This is first
First
reading,
reading. First reading.
so this will be set down for the meeting of January 7th, 2025.
Yes, ma'am.
Can I
We are
please have
voting on 40.
44? I have a motion by
Move.
Councilman Love, second by Councilman Mello. Roll call, Councilman Monk.
I'm sorry, Councilman Schwartz, your light is
Yeah,
on.
we just have some questions.
Yes, in terms of, I personally have some very considerable concerns about this ordinance. I've been on this council for
A long time.
a long time. When I started on this council, one of the most,
Councilman Garcia has been here much longer than I.
yes. One of the most significant issues that we had was the current rent controls in place, in that the combination of the rent controls and the inability of landlords to raise rents, they then went and did property tax appeals, claiming that they couldn't cover the cost of the property taxes, and won consistently. And that was rectified by doing two things, two very significant things to the rent controls. One thing was to take the property taxes out of the equation, in which any property tax increase, regardless of how wide or how much, got added to the top of the rent, no questions asked, free pass. And there was the flip side of that ordinance was that if the property managed to get a successful tax appeal, every dollar of the tax reduction had to be refunded dollar for dollar to the tenants. And overnight, all of the tax appeals ended overnight. In addition to that, we did a permanent vacancy decontrol, which means once the unit went off of rent control, it never, ever again returned to rent control. As a result of that, I think as a direct result of that, the city of Passaic has become extraordinarily attractive to investment because people know they can make an investment, they can do what they want, and they're not subject to any other constraints. Now, I understand there are concerns of what's going on here, but once you start putting in any type of cap, whether it's 8% or anything else, now the 8 ball is behind the developer to demonstrate why his thing is, why he's allowed to do that. And you have a lot of developers which have already invested considerable money into the city of Passaic specifically because there was no rent regulation. These people run very well-run buildings, and to start putting the level of controls over them, first of all, they're not going to do any other projects here. It's going to completely change the environment of why Passaic has been so attractive to this investment. And that's why I'm extraordinarily concerned about it. I understand we need to put in some definitions to try to accommodate a rent leveling board so that there's a forum to have things, but to have it go past that set of definitions and start putting in controls, which can have negative impacts in terms of the considerable investment which has gone into the city. I am extraordinarily concerned about doing such an ordinance.
If I may respond, if the council president would allow, and I'll be succinct. I am proud of the development that has occurred over the years and admire the work that was done prior to me. Our city wants to attract investors. We have a responsibility to the residents of the city to protect them. I believe this council has done so over the years. I want to share this. I was adamant that our administration present this ordinance to some of our bigger developers who agreed that this was reasonable. These building owners. I would push back that not all are responsible as you described in terms of business and in terms of property owners. Some are derelict and some take advantage of vulnerable individuals. We are slowly approaching a time where we have a population that may be even more vulnerable because of the outcome of certain elections and certain rhetoric that has been shared. There are individuals that could be subject to rent increases and threats. I believe this is a reasonable approach. What is being requested often of us is not reasonable. I believe that this protects individuals who we are seeking to protect without in any way creating such a burden or such an issue with potential developers. And I don't know how many more $50 million projects we're getting in the city of Passaic. I don't see 10 or 20, but if we can get them, great, ratables. I think that our track record has created relationships where people understand this council and this administration look to work with those who want to invest in our city. I think the number is high enough that the increase will still make a benefit or still result in a benefit for the property owner. It excludes new projects, so that is not an issue. But we are being inundated with constant complaints by residents. I know the council members could speak to it directly. It is every day we're getting these complaints of individuals going, my rent went up double. I think, God, I don't know what that's like. And you're right. If there's a tax increase, but caps have occurred. There's been caps on tax increases. Caps sometimes, they serve a purpose. This cap, again, I think is reasonable. So, Councilman, to be succinct, because I don't want to revisit every argument that's been made this evening. I believe that investment will continue. I believe our residents will overwhelmingly respond with gratitude and not be subject to the direction of organizations or groups that don't necessarily have the best interests of the entire city in mind, but have a specific goal that benefits their agenda. I think that this is a good ordinance, but I respect the decision of the council. I would ask that it be considered on this first reading because I think that we have a responsibility and a duty. It is not an issue in Passaic. It is a statewide issue. It is an affordability issue. Every person who's running for office keeps bringing it up. The complaints are coming from every single city. And I think we have an opportunity to be at the forefront, leaders in this in a responsible way that does not hurt investors and at the same time protects the renters. And we have an overwhelming majority of renters in this city. The majority of our residents are renters. They are not developers. Now, everyone knows I'm developer friendly, but if we do not have an appropriate response to protect from these exorbitant, outrageous, and malicious tax increases, we might find ourselves with our backs to the wall and behind the eight ball at a swelling push that the city take extreme measures. And I think, again, I'll conclude, this is a pragmatic and responsible approach that considers the developer and the investor while protecting the overwhelming majority of residents that are renters in the city. Thank you.
Thank you, Mayor. Councilman Monk?
Yeah, thank you. Can I get some clarity on this ordinance when it refers to a below market rent increase?
Yes, of course. So as part of your package, we included what the HUD guidelines are for rental limits in our region. So that's part of your backup. We're under the Passaic, Bergen, and Sussex region. And if you look, there's two sets of rents. There's a moderate income, and then there's a low income rent. I want to say, and I'm going by memory now because I'm looking at the ordinance, not the numbers. Roughly a low rent for a 2-bedroom is like $14.81, something like that.
1458.
1458. So what this ordinance says is if you purchase this property, right, and your investment, and somehow you got the mortgage because you had to show the rent roll at whatever it was. So let's say that you get the mortgage and it's at $900, not $1481, right? What this ordinance allows the purchaser to do is to go up as high as 20% rental increases year over year until they hit that 1481 number. So it triples the increase amount because they're so below the low market rental within our region. So what that does, and the mayor was adamant about balance, is that the least we can do to stabilize and balance is get the landlord to the minimum low rental limit if it's significantly below. It's fair, and it's statistically analyzed by HUD. It is fair for the tenant, and it is fair. It's a fair rent for the landlord. So we carved out at the mayor's request a specific section to allow for this additional increase because it would be unfair to keep it at the $900, right? When the low income rentals, these are people below the poverty line, would be at $1481.
And this ends in 6 years. I just want to make sure everyone knows. This is 6 years. After 6, this is not a decision that lives on perpetuity forever. 6 years, the council has the right to revisit if there is an effect on this city that the council does not wish to continue. I will leave it there for the council's consideration.
It has a sunset. And there was a specific purpose why 6 years was chosen.
What was the 6? Sorry.
So the impact, without going into detail, considering after the pandemic, which already exacerbated pre-existing issues of individual communities sometimes faces many hardships, we considered the impact of it in a term that would help in terms of recovery, an approach that we can justify as a city. It takes the market about 6 years to recover or to set itself right, and a 6-year term is an appropriate amount of time where the council could revisit and say, we don't want to continue this, or this has worked out very well and we've seen increased development.
Yeah, I missed that. I didn't understand the 6 year.
Yes, after considering the pandemic, the many years of the pandemic, or how many years of the pandemic, and having some conversations as to how long it takes for the market to correct itself, cycles in terms of when rent increases, investments, the impacts in city, we decided that 6 years, again, there's an exact science, would be enough time where it would have significant impact to protect residents who just came off of a pandemic, while not being so long that you couldn't imagine a council within this lifetime saying we can revisit this.
But Mayor, if I may, after 6 years, what happens?
It comes before the council. It ends. It has a sunset, so it automatically ends. And then the council could decide, bring this back or no. But it's a sunset. It ends in 6 years. It is a 6-year approach to protect the tenants who are being targeted by some landlords who feel that the tenants have no recourse.
If one could argue that it's not every 6 years that we have a market cycle, but 4 years. Would that change anything?
If I can be candid, I wanted it to outlive a term and not fall into a 4-year or 2-year term, that it would not be confused as a political move, but rather a very specific and considered approach at addressing issues that resulted after the pandemic. You've had families come here directly and say,
in terms of time.
Understood.
Thank you. Councilman Schwartz.
Can I get some clarity on paragraph B of, it says the provisions of the section shall supersede any other provision of this chapter 231.
So is it what B, Councilman?
On
Is it
page
231, 23B?
Yes.
20,
Yes.
23B?
Yes.
The provision of this
Yes.
shall supersede any provisions of this chapter with which, okay. What would you like? What's the, you just want to
Okay.
explain?
It says period, with the exception of provisions contained in 231.2, 231.4. Is that it was,
So the reason that is, remember, we talked about those capital improvements and we talked about those hardship waivers. We wanted to make sure that that was still in effect, and this would not limit that from happening because of everything we just discussed here this evening. Those were reasons why that was carved out.
but 231.2 and 231.4 also talk about a permanent vacancy decontrol.
Which continues here. But the biggest issue is post 99 and pre 1999. So we didn't want to take out of effect what the current ordinance says, right? So the current ordinance says if you were there before 99, there's specific provisions there because you've been in that unit since 1999. We didn't touch that. This is moving forward. That's why it was called the rent stabilization of 2025. So that anyone who's been in, and that's probably the ordinance you were discussing originally, anybody who's been in their unit since 1999 still gets the benefit of whatever the ordinance read today. Moving forward,
So
these
this
are the
is not
provisions.
relevant to those tenants?
This is not relevant to those tenants. Those tenants fall under the original ordinance and would remain the same.
And when that tenant vacates,
It goes back to uncontrolled.
but now it's subject to this?
Yes. Because it's post 1999. So it would be, once it's vacated, everything we talked about this evening,
But you have a number of units which have been vacant since 1999 and therefore are not currently subject to rent control. Those would be subject to this?
so if they're vacant,
In this
right?
scenario, they've been
No.
vacant since 1999.
No, they have not been, they were vacant at some point since 1999, but they've been occupied for the past 5 years.
If they're occupied within the last 5 years and they don't fall under the new construction exemption, they would fall under this current ordinance.
So I'm still not clear. It says, with the exception of the provisions contained in 231.2 and 231.4, which provisions? Those provisions basically.
Those are the pre-90, those are the pre-1999. So let me pull up 4. All right, so number 2 is the establishment of the 1999 ordinance, and it goes all the way. And then 4 is increases to base rent. So 4
Which
is
also
specifically
says,
for those pre-1999 individuals.
correct,
So
but
those
4
are the
also
only ones.
says that there's a permanent vacancy decontrol to those individuals, to those units.
Yes, it's decontrolled. So which means, so let's take your scenario. Right now, I'm pre-1999. I'm subject to this $25 a month, right? Maximum, right? Now I leave. You can set it at whatever you want, whatever the market can bear. You'll set it, right? And then you'll fall under if this ordinance passes, you'd fall under the
But
requirements of this
231.4
ordinance.
does not just say vacancy decontrol, it says a permanent vacancy decontrol.
This would control.
I'm sorry?
This would control.
Yeah, our current ordinance would control anything past 1999.
So I don't understand what it means with the exception of the provisions in 231.2 and 231.4. Those are some of the provisions. Because I'm not understanding the verbiage.
So
in paragraph B.
where do you see permanent? I'm trying to find permanent. I don't see that
I don't
here.
recall if he uses
Under
that word,
4.
but there's no,
Sorry, he's trying to respond.
I don't know if
Councilman,
he-
he said, where do you see permanent?
I don't know if he uses that specific word.
So
But
the word permanent may not appear?
That's I pulled up the ordinance. I'm reading it right now, and I don't.
So, because I want to make sure you guys hear each other when speaking. I don't believe the word permanent is there.
As it was, at the time it was written, that it did not go back into effect once it was vacant.
Right, because you didn't need to state it, right? The moment it became vacant, it was not part of this ordinance. So you didn't have to state in perpetuity. It automatically went away.
But whatever
Whenever it got
verbiage it says
vacated.
over there, it makes it was made, I don't know if he uses the word permanent, but whatever verbiage it does have over there, it was a permanent decontrol.
Right, what I'm saying is, by the mere fact of the vacancy, it's decontrolled because this doesn't no longer apply. So it was decontrolled.
I'm sorry, our rent leveling attorney, if the council president would allow, could give
Yes,
a
please.
specific response.
You can go up to the mic.
Council President, Councilman Schwartz, I can explain the provision if you like. I'm Chris
Could you bring the
Rodriguez.
mic up to you,
Oh,
please?
I'm the rent leveling attorney for the city of Passaic.
Again, your name, sir, I'm sorry.
Christopher Rodriguez. Thank you. Now, if you were to look at the current code under 231-2B, there's a specific clause, and I have the code before me that says, the terms and provisions of this chapter shall not apply to any dwelling unit which becomes vacant after the effective date of this section, nor shall it apply to any multiple dwelling housing space rented or offered for rent for the first time subsequent to the effective date. So the effective date of 231-2 serves as the control date for the original rent control provision. And the effective date was December 9th, 1999. So I believe, Councilman Schwartz, that might be what you're recollecting as the permanent
Yes.
control date for becoming off of rent control.
One second, please. Councilman Schwartz, does that answer your question?
So you're saying that is no longer relevant to that and would now be subject to this?
That's correct, because if you go to the new proposed ordinance, it exempts itself from the establishment clause. So anyone that's under the 231-2 requirement is still protected by those requirements, but then anyone who's outside of that would fall under the new ordinance. Of course, unless the unit was vacant and you're offering it for rent for the first time, there's no such restriction. In other municipalities, there are restrictions against increases for subsequent tenants, even if the unit is becoming vacant. We're offering no such restriction in our proposed ordinance.
Okay.
Thank you, Councilman. Councilman Monk?
Thank you. So I
Thank you,
just want to
Council.
go back to the explanation.
Excuse me, by the way, thank you, Mr. Rodriguez.
Oh, of course, no problem.
So on this, Mr. Business Administrator, what you're referring to earlier about the low-income rent limit of 1458. So if someone was below that, they can increase 20% a year, right? Do they need to demonstrate before the rent leveling board of renovations that they've done, or they could automatically go up 20%?
No, so I believe in the ordinance, it has a component in which that has to be verified so that someone doesn't come into the mayor and say, I got my rent doubled, right? Let me just pull that one up because I'm going from one to the other, so I apologize. Let me just get to that section here. Okay, so application below market rent, a property owner who is currently renting a dwelling unit that is below the applicable low housing rent can increase up to that number for the 20%. Accompanying an application, the property owner must submit to the rent leveling board copies of updated landlord tenant registrations and things of that nature. And then they'll review the application, which is under item 2. And then item 3 is the 20% limit.
So they don't have to necessarily do
Work.
improvements.
They don't have to do work.
Okay, so then this chart has low home.
Yeah,
rent
so I don't
limit.
want you to get confused on the chart because it's based on income limit. This is not based on income limit. It is based strictly on rent. So basically what we're saying is the lowest income in our region for a 2-bedroom is $14.58. We're saying that if you're below that, the minimum, like you should be able to go to at least the lowest we're allowed to in our region. So if you're at 900, you can get up to that 14. But just like the mayor said, you don't want to grab somebody and completely double their rent from one moment to the other. So it allows triple the amount increase till you get to that number, and then you can follow the rest of the ordinance. So it's trying to facilitate the landlord getting to that number faster because they're so below market. Now, none of this precludes the landlord, because I know you said something about repairs. None of this precludes the landlord for going in for a hardship variance. No, I said variance. I'm using my zoning and planning. for a hardship request or a capital improvement request if they're going to gut the building, right? Just to reiterate what the mayor said, this is not for maintenance or for general emergency repairs because you didn't fix the roof for 10 years and now there's a hole in it, you're fixing the hole in the roof, right? It has to be capital improvements that you made that somehow benefit the tenant as well, right? So those are the criteria that's already been established in the ordinance. So nothing precludes you. Let's say you are at that $900 and you say, well, $1,458 is not enough, right? You can say, this is the fair market. This is what I've done to the property. This is why I deserve this hardship. Or if you don't want to go through all that headache, you just do the 20% and get you to whatever number you can live with. But that's a way to limit that impact on the tenant, to not get that double, and also give an incentive to the owner to say, we're not going to hold you to that $900 or $1,000. Let's say it's $1,000 under this ordinance, you get $80, not anymore, right? Now you can do 20% of that.
Okay, so.
Councilman, I'm sorry, Councilman Mon.
So that's the low income rent limit. You go 20% at a time to get to that number, okay? And then after that, what happens?
The ordinance would apply.
Of the 8% per year.
Or the hardship or the
But if it takes you 4 years to get to that number, then it applies for 2 years and then there's a sunset on this.
Right.
It's only 6 years. So if you're doing 20% for them, just doing the math, if you're doing 20% for the next 4 years, then you only have 2 years that you worry about this, and then there's a sunset.
And then you could, one would argue it sunsets, the council doesn't do anything, they could then in 6 years raise it to whatever you want.
Do what they wish.
Right.
So what happens, I guess more of a legal question. If I rent an apartment for $2,000 and I give a 2-month concession, or I give 2 months free, what is my rent?
You've still established the base rent at $2,000.
Does it say
Okay, you're not stuck at the 2 months free.
No, I just want to know what, so this
No,
was
it
for your
would be
base.
considered 2,000.
And a new construction, when you build a new building and you take a construction loan, right? And after you finish construction and you occupy the building, then you put on a permanent loan. Which loan, you said there's a state statute that says that any new construction for the life of the mortgage, there's no restriction.
Right, that would be the permanent mortgage, it would not be the construction.
Not the construction mortgage.
The construction loan, you wouldn't,
Is that
extensively, you wouldn't be tenanting that until the end of the construction loan, right? Yeah, and I know there's concessions and there's, you may be getting an OC before you switch, but the idea is when it's tenanted, and that would be at the final permanent mortgage.
Okay, so I guess really what, I understand the purpose of this ordinance. I get it 100%. Obviously, someone's living somewhere and all of a sudden their rent's double, right? One thing I don't know, and I don't know the answer. I'm wondering if we have any experts, right, that know the answer to this, how this impacts. I think Councilman Schwartz touched on this earlier. How does this impact the valuation of buildings? In other words, that we know there are a lot of buildings here in the city, right? Many, many apartments. Big percentage of the city is apartments. And apartments are evaluated, or valuations are done based on income, right? Based on profits, right? If we are prohibiting, if we are slowing down the process for landlords to bring an apartment up to market, right? Now, we all agree, if an apartment's $800, that's way below, right? Now, if it takes someone 2-3 years to get up there, as opposed to 1 year.
Or if they come in with a hardship consideration.
Okay, right, okay. But we are essentially lowering the value of these properties, which gives the owners of these buildings a tool or a reason or an excuse why they should be paying less taxes. Which let me now, because a large percentage of the properties in the city are apartments, So we're giving a very big percent, potentially, a large percent of the buildings, of properties in this project to go for tax reconsideration. And if they are successful, and we know that income producing investment properties are based on income, there's a good chance they will win an appeal. What happens then is then the tax will get shifted to the homeowners. Someone got to pay our bills, right? So if the taxes are lowered on apartment buildings, it means all those taxes, the taxes will get shifted over to homeowners in the city of Passaic. How do we deal with that?
One, I would say there are many reasons why developers would make arguments that taxes. There are many reasons why homeowners would, or property owners would make arguments that their taxes should be lowered. This would not be the one reason why they come to the city or tax appeal or take on a tax appeal. I can only respond as I have said consistently. Look, I don't believe in extreme positions. Just don't. I don't like the idea of restricting rent increases to the point where people flee and say, I can't make money in the city and I don't want to invest. I also understand that there's a vulnerable population, and they're not just in our city. I've seen other municipalities take extreme approaches, either a callous one that only considers investors to their detriment, if not immediate in the future. And then again, the other side, which I've mentioned, those who take political positions and pander to a group, and then the city is hurt. I genuinely feel that we have vetted this, that we have addressed and considered every side, that we have addressed legal issues, that we put a sunset on it for that purpose, because we do not believe that we hold infinite wisdom or have it and aren't so arrogant to try to impose a decision now on those who would serve in the future. We have utilized our attorneys, but I know this council also is concerned for the residents. I do not in any way want to portray this as my crusade or fight. We have so many residents who keep coming and saying there's no defense. I've seen organizations come in and rally individuals and tell them, let's all go and fight. And we've withstood these things before and have an extreme measure. Again, I don't support those. I believe that this is a reasonable approach, that we would be at the forefront, that we have gone beyond expectations, and I've heard it directly from developers and investors in this city to encourage investment, over 200 million on our east side. People know we are not known as the city that will not help. We want development, but not at the cost of the lives of our residents. We need to provide them a defense. I believe in this ordinance wholeheartedly. I believe the spirit and principles behind it is something that the entire council can get behind. Developers have, and investors have professionals to speak on their behalf. They have attorneys, they have architects, they have engineers, they have bankers, they have people to defend them. The tenants don't. They have us. And we are here right now charged with an opportunity to put something reasonable before them. And I believe that's what we have before us. So I don't know. I would lie to you if I told you that I think it have zero effect on the market. But I would propose that anyone who thinks that they know for 100% it would have an adverse effect on the market can't say that for sure. They don't know the future. I do know we have a problem before us, and we've taken a reasonable approach that has been vetted by attorneys, that we have presented to developers who said, this is reasonable, thank you. And they understand because they hear the outcry. Some of them have been on the news for people attacking them. They're going, we'll work with the city. And that's what we're doing here. So again, I think new projects are exempt. I think residents will be protected, and I think there's recourse and measures that can be taken by the property owner to reach up to market rate if they're not there. And then in 6 years, I believe that it ends. I know that it ends, and the council can revisit it. Thank you.
Thank you, Mayor. Councilman Schwartz.
So I really appreciate, Mayor, I really appreciate the clarity that you've provided on this. I understand where your thoughts are coming from, and those are valid issues. At the same time, I would, if the council's amenable, I would feel more comfortable tabling this to the next meeting.
I object, and I put that on the record, and I have never done so, but Councilman, and I I will take this opportunity to say that I don't want to cut you off, but this is how serious this is to me. As mayor, you have all authority to do so. You are the council and the legislative body. But often it's been the case that an individual's opinion gets to determine whether the entire council gets to speak up. It's fair, if the council allows. But we put a lot of work into this and a lot of study, and I have not heard, and I've often backed off and acquiesced. Even when I have believed in an ordinance, I've deferred to the wisdom of the council. I would politely and respectfully request that you put it up for vote. And if the council by majority rejects it, then I'm fine with that. I will live with it and I will continue to fight for an ordinance that defends those who are victims to abusive, malicious, and evil property owners who know that there's a population that don't have money for attorneys, can't fight. If this was one incident, and I have never pushed for an ordinance over one incident, we are overwhelmed by complaints of residents that go, my rent is being doubled, the court won't hear me, I don't have a money for attorney, what are you guys gonna do? And I cannot go back to them and say, when I had the opportunity to fight for it, I backed down. So I'm asking, allow the council as a whole to consider it. And if the council as a whole rejects it, that is fair, because that is the process, the correct and most ethical process. There is a checks and balances. I don't want to deal with the organizations that keep screaming for rent control because I think it's a ridiculous and irresponsible approach, and I don't want rent control of the city. But I admit something has to be done in defense of the residents. And I am not one of these liberal progressives, and I'm not going to get into this soapbox of politics, but if a few people say, I wanted to bring $50 million to Passaic, and I'm not bringing it because you defended the poor and the vulnerable, I can live with that. I think the city can because we've had record investments, and there's never been an approach under this administration that has made investors flee. I don't see anything in the ordinance that would do so. So I just ask that, Councilman, you have the right to request it, but I, as mayor, am asking that you put it up so we could hear from the council as a whole, because it is that important. It impacts the entire city, and I don't have an answer for residents. And I can't do this through executive, and I wouldn't want to do it through executive power, but I have a responsibility to respond to them, and they're coming every day with this.
I appreciate the considerable thought that went into constructing this. It's clearly something which was not done randomly or haphazardly, and clearly there was a lot of thought that goes in. And it's something which is worth considering. One of the concerns that I continue to have, so what happens in year 6? So once you have something like this, there would be considerable pressure to vote and renew it for another 6 years at that point, because once you have something like this, it's not, and there's when we have the threat of that thing expiring, it would be a lot more pressure to renew it than you have today, even perhaps.
It may be, or it may not. It may work. It may work overwhelmingly, and developers may continue to invest. But what happens if we don't? I will take your scenario.
I'm not suggesting that we not do it. I'm asking that we table it till the next meeting.
But this would be a first reading, if I'm correct, right? This would be a first reading. So conversations can continue to have. And I'm not saying this is the approach, but perhaps in other municipalities, the tabling results in the death of 1,000 cuts as we continue to speak at it ad nauseum and then it's gone. And all I'm stating is this: if it's a consideration for the entire council, because all of us have to deal with it, you gave a scenario, what happens if there's pressure? If we don't pass it, and we have a large number of residents that are out on the street, because they got evicted, because raises continued, because we did nothing, then I can make the argument that there would be overwhelming pressure to respond now on the extreme, perhaps adopt an outrageous rent control ordinance because political expedience would require. Right now, I don't believe that I'm being motivated by political expediency. I would hope not, and I don't believe any of us have. But I am telling you genuinely that we have residents coming every day. And if it was not the case, I would not push here. But it is every day. And I speak to landlords and ask them, listen, can you consider not raising double? I have no means of forcing that. I don't have the power or authority to say you cannot double this person's rent. But this collective body has the authority to implement an ordinance that gives people a responsible approach while still considering whether the landlord can raise. So all I'm asking is that it be considered for first reading, and then every question that is necessary, as it's the right and the responsibility of council members to ask them during the week, so that our professionals who have worked so hard on it can answer them. And if you're confident in the next meeting, we pass it, and if not, then I understand. But to table it now, I have not seen a reason why tabling it, unless the council as a whole says we don't like it. But that's not what I'm hearing. And I have a great deal of respect and admiration. I believe you're motivated rightly, Councilman Schwartz. I've always considered that your approach has been one that is considerate and reserved. And I'm not saying that to win you over. I know what your position is. But I'm telling you, I'm dealing with this every day. Every day I'm getting messages from families, and you can ask some of your colleagues because they're getting it as well. And I don't know how to respond to them outside of the most responsible ordinance that we can come up with, and I believe that's what we have before you. So all I'm asking is that you consider a vote of the whole, and if there is an objection, that be recorded, but that we get an opportunity to move forward, because the pressure's on and there are people, real people suffering.
Councilman Schwartz, you made a motion. Is there a second to the councilman's motion?
Can I just,
Hearing none. My colleagues, Mr. Mayor, members of the administration, let me first join with, I think, all of my colleagues who have stated this is a result of expert work. I remember so well the ordinances that in previous administrations this council has been asked to act upon, and the difference is frightening. Nonetheless, this is one of the most, if not the most significant pieces of legislation that many of us will ever pass or deny. As such, it has tremendous gravity. I am concerned about this council, which has worked so well together, for that to be torn asunder. However, there is no doubt that this is for first reading. It does not pass unless it goes through second reading. Respectfully, I will accept a motion to accept for first reading, second reading to be on January 7th.
Second.
Motion and second. Roll call, please.
Councilman Monk,
yes.
Councilman Love,
Yes.
Councilwoman Mello,
Yes.
Councilman Schwartz,
Yes.
Councilman Garcia,
Yes.
Councilwoman Colon Montañez,
Yes.
and Council President Scher.
Yes, and if I may thank the council and the administration for the tremendous work that has been invested here. If there's new information, I would hope that it would be shared with all of us. This ordinance is up for second reading. It has just been introduced, no more. And the council certainly has any number of things that it can do to make the ordinance even better or whatever. That being said, ladies and gentlemen, members, colleagues, is there a motion to adjourn tonight's
Council President,
43B, we have to entertain.
43B, appointing members to the rent leveling board? I believe we can do that at the next meeting, perhaps with more insights.
No,
Is there a motion to adjourn, please?
so move.
Motion?
Second.
Motion and second to adjourn. Roll call, please.
Councilman Monk, Councilman Love,
Yes.
Councilwoman Mello,
Yes.
Councilman Schwartz,
Yes.
Councilman Garcia,
Yes.
Councilwoman Colon Montañez,
Yes.
and Council President Scher.
Yes, thank you.
Thank you.